Senator from Arkansas.
I ask that the quorum call be dispensed with.
Without objection.
Mr. President, my colleague from Arkansas and I would like 10 minutes maximum, I think, to extend special birthday greetings to former Congressman John Paul Hammerschmidt. So with the President's approval, we'll just turn it over to Senator Boozman and let him lead off.
Without objection.
Well, thank you, Mr. President. It really is a pleasure to be with the senior senator from Arkansas discussing somebody that we both have a great deal of affection for, and that is the former congressman of the 3rd District of Arkansas, a district that I used to represent. Congressman Hammerschmidt represented the district for 26 years, and he just recently celebrated his 90th birthday on May the 4th. John Paul led a dedicated life to public service. In fact, that is truly an understatement. Along with that, he served as a combat pilot during World War II and is part of the greatest generation. Once he returned home to Harrison, Arkansas, he ran the family lumber business while spearheading efforts to create a two-party political system in the state of Arkansas. John Paul helped mold the political landscape of Arkansas, and he never lost sight of the reason that he was doing that, why he worked so hard to provide a two-party system, and that being the people of Arkansas. By the time he was elected to Congress in 1966 as the first member of his party to represent Arkansas in Congress since Reconstruction, John Paul had a reputation of working to help others. He did that for 26 years as a member of Congress. By the time he retired, he was the ranking member on the House Transportation and Infrastructure Committee. He served in Congress with the same enthusiasm that propelled him into office and was well respected by his colleagues on both sides of the aisle for his strong work ethic, approach to getting things done, and his responsiveness to constituent service. 11 years ago, as a newly elected member of Congress, who also represented the district that John Paul used to represent, he gave me advice that I continue to follow, and that is that the key to good governing, the key to good public service, is that once elected, there aren't any more Republicans, there aren't any more Democrats, there's just the people of Arkansas, the people of America, and that we need to take care of them. His words ring true today as they did 11 years ago. His efforts to work with his colleagues in both political parties benefited Arkansas and America and showed what it truly means to be bipartisan. Despite being in the House minority, he was able to achieve much success in Congress because he recognized that the key to good governing and good public service is that you treat everyone fairly and set aside political differences. This ideology allowed him to be influential in a variety of different areas. He is accredited with securing improvements for roads and infrastructure projects, including Interstate 540, the Northwest Arkansas Regional Airport, protecting the Buffalo River under the designation as a national river, and setting the example of exemplary constituent service that we strive to continue today. He is showing no signs of letting his age slow him down by any means. He continues his service on numerous boards and for organizations with the same vigor he demonstrated throughout his career. John Paul played an important role in our state's history, and he still continues to play an important role in our state's history, and also played an important influence on me as he did so many others in Arkansas. I consider him a friend and a mentor. I finally recall the first time that I was in Washington being sworn in 2001. He took my brother and I to the members' dining room, and again, it was just a very, very important time, and just his hospitality to all of us throughout the years. It was so gracious. I appreciate very much his advice and friendship, and John Paul is able to leave his fingerprints on projects important to Arkansas through his hard work, dedication, and commitment. He never forgot about the people he was sent to Washington to represent, and we are truly grateful for his tireless efforts to represent the people of Arkansas. Senator Pryor.
Thank you. Thank you, Mr. President. John Paul Hammerschmidt is 90. There are many colleagues here in this chamber that serve in this body today who worked alongside him either during their service in the House or just when they were in the Senate, worked with him on the many things that Congressman Hammer-Smith did over the years. He really is one of the Arkansas greats. He served Northwest Arkansas, which is the 3rd Congressional District, for 26 years in the Congress. Looking back at his career, he's once said, quote, "The only reason people should be in public service is to purely serve other people," end quote. Indeed, he set the bar for constituent service, from delivering a Social Security check to a senior bogged down in bureaucracy or fighting for disability benefits for a veteran. Today, each of us in the Arkansas congressional delegation tries to emulate his legendary casework management. One of John Paul's most significant contributions was the preservation of the Buffalo River as a free-flowing stream. According to the Pryor Center for Arkansas Oral and Visual History, John Paul first floated the Buffalo at age 12 after taking wood from his father's lumber yard to build himself a boat. Nearly 40 years later, he established the Buffalo as the first national river. This was not an easy achievement, but one that was built with persistence and through relationships within the community. Today, tens of thousands of Arkansas families, but also American families, including my own just a couple of months ago, enjoy floating the Buffalo National River. John Paul also used his time in Congress to help Northwest Arkansas expand its infrastructure to keep up with the region's fast growth. For those of my colleagues who don't know, that's one of the fastest growing sections of the entire country. As a member of the Public Works Committee, John Paul was credited with securing bipartisan support on key infrastructure legislation. We could use a little bit of that magic today, by the way. You can't go far in Northwest Arkansas without seeing his impact. We have the John Paul Hammer-Smith Highway, an access road to Carter Field near Rogers, an industrial park at Diamond City, the John Paul Hammer-Smith Plaza, the John Paul Hammer-Smith Business and Conference Center at North Arkansas Community College, the John Paul Hammer-Smith Lake at Fort Smith, and the John Paul Hammer-Smith Federal Building in Fayetteville. Upon John Paul's retirement, former Congressman, Commerce and Transportation Secretary Norman Mineta spoke on the floor of the House of Representatives saying, quote, "There is no individual in the House who is more loved and respected than John Paul Hammer-Smith. His honesty, gentleness, decency, and integrity are second to none. Don't be swayed by his quiet manner, because underneath is a man with strong convictions, a sense of purpose, and a keen desire to get things done," end quote. It is fair to say that John Paul never actually retired. He remains involved in many civic organizations, including Northwest Arkansas Council and March of Dimes. Higher education continues to be one of his priorities. He serves on not one but two boards of trustees, one at the University of the Ozarks and the other at Arkansas State University. John Paul Hammer-Smith has spent decades serving others and giving back to his community. I'm pleased to have this opportunity to pay tribute to all he has achieved so far and wish him a happy 90th birthday and many more years of health and happiness. With that, Mr. President, I yield the floor. And suggest the absence of a quorum. Clerk will call the roll.
Mr. Akaka.
Going into a quorum call here on the floor of the Senate. Earlier today, there was a colloquy between four senators talking about debt and deficit reduction. And coming up in about 10 minutes, we expect two judicial nominations to be considered and votes on those nominations, as well as a vote on whether to proceed to an export-import bank procedural vote. That's going to be at 5:30. Also some news from the campaign trail. Ron Paul, the congressman from Texas and Republican presidential candidate, effectively ending his presidential campaign today. But he urged his supporters to continue working at the state level to fight the candidacy of the presumptive nominee, Mitt Romney. As the AP reports, Ron Paul issued a statement saying he'll no longer spend resources campaigning in the remaining primaries. And Ron Paul, a longtime congressman, not running for another term over in the House. The House today out. They'll be coming back in tomorrow at 2 p.m. Eastern.
Mr. President,
Senator from Vermont.
President, I ask that the call of the quorum be dispensed with.
Without objection. Under the previous order, the Senate will proceed to executive session to consider the following nominations, which the clerk will report.
Nominations: George Levi Russell III of Maryland to be United States District Judge. John J. Thorpe, Jr. of Illinois to be United States District Judge.
Under the previous order, there will be 60 minutes of debate with respect to these nominations, equally divided in the usual form.
Mr. President, I ask consent that the time run to 5:30 on the nominee, which would be approximately 50 minutes, but that time be divided in the usual order.
Without objection.
And, Mr. President, I ask that my statement on the judicial nominees be included in the record as if spoken.
Without objection.
And, Mr. President, using the time allocated to the majority, I ask that my remarks be seen as in morning business.
Without objection.
Mr. President, I was fortunate to be able to attend the argument before the United States Supreme Court on the constitutionality of the provision in the Affordable Care Act, providing that individuals should take personal responsibility for paying for their health care by obtaining health insurance or paying a fine. I've watched a lot of arguments in the Supreme Court. Obviously, my position as chairman of the Judiciary Committee, I pay close attention, as do all members, of what goes on there. I heard a great deal of instant analyses from commentators after the argument, including predictions of how the court will rule. What I didn't hear was much devoted to the role of the Chief Justice of the United States. I saw a Chief Justice that day when I watched the arguments who I thought deemed well aware of the significance of this decision. Chief Justice Roberts had not been appointed when the court intervened in the presidential election of 2000. But he certainly saw the reaction to that decision, Bush versus Gore, a 5-4 position, a decision the country viewed as partisan. In fact, many in the country felt that 5 people on the Supreme Court decided a presidential election, and actually for the person who got less votes than the one they said lost. But the Chief Justice did participate in the court's recent 5-4 decision, Citizens United, that divided along ideological lines, and it continues to engender significant backlash. That decision led directly to the super PACs, and campaign excesses are now plaguing our Democratic elections, actually plagued this year's Republican presidential primaries. As bad as its effect on both Republicans and Democrats and elective offices, I believe it's contributed to the further erosion of the public's confidence in the Supreme Court to be an independent arbiter. The constitutional challenge to the Affordable Care Act is the current instance in which narrow ideology and partisanship are pressuring the Supreme Court to intervene where it should not, to override the law and constitutional legal understandings have been settled since the Great Depression, but also to overturn the actions of the people who are elected to represent all Americans in both the House and the Senate. And I was struck by how little respect some of the justices showed to Congress, how dismissive they were of the months of work we had, hearings, dozens of hearings, or the committee actions, or the debate of amendments and motions and point of order on the Senate and House floor before the measure was enacted, how that was almost summarily dismissed by some. Now, I'm not going to be offended if some of the justices don't like us personally. or disagree with the policy judgments reflected in the law as individuals, as citizens, as human beings. They're entitled to their personal views just as you and I are. But as justices, they are supposed to begin their inquiry by respecting the will of the people as reflected in the work of Congress, and to defer to Congress unless the laws we pass violate the Constitution. Acting out based on their personal views in this matter would be the height of conservative judicial activism. Let me repeat that. Acting out based on their personal views in this matter would be the height of conservative judicial activism. The Chief Justice seemed to understand that deference to the elected branch is fundamental to the proper exercise of judicial review. I was struck that more than once he commented on the extreme arguments coming from other justices by knowing they weren't being fair. Well, Chief Justice Roberts was right in that regard. I thought I saw, at least the day that I watched, I thought I saw a Chief Justice who understands the importance of this case to all Americans, including those millions who would otherwise continue without health care insurance or access to affordable health care. The kind of health care insurance and access to affordable health care, Mr. President, each one of us in this chamber have, and each member of the Supreme Court have. We all remember when the Chief Justice was nominated, he testified that if confirmed, he would act with judicial modesty. He would honor precedent. He would acknowledge the limited role of the judiciary and seek to bring the court together. Well, when I voted to confirm Chief Justice Roberts as Chief Justice of the United States, and many of my Democratic colleagues voted the other way, and I respect them for that, I said in voting for him, I was voting with hope and faith. I credited his testimony. I trusted he would act to fulfill his responsibilities in accordance with the testimony he gave to the United States Senate. I said then that if I thought he would easily reject precedent or use his position on the Supreme Court as a bulwark for activism, I would not have supported his confirmation. I was encouraged by the assurances he gave during the confirmation process that he would respect congressional authority. Well, this case is a fundamental test. After all, he relied heavily during his hearing on the recent Gonzalez versus Raich decision as controlling precedent in upholding congressional authority to act under the Commerce Clause. I trust that he will be a Chief Justice for all of us, and that he has a strong institutional sense of the proper role of the judicial branch. It is the Supreme Court of the United States, not the Supreme Court of the Democratic Party or the Republican Party, not the Supreme Court of liberals or conservatives, the Supreme Court of the United States. And the Chief Justice is the Chief Justice of the United States, all 320 million of us. And given the ideological challenge of the Affordable Care Act and the extensive supported precedent, it would be extraordinary for the Supreme Court not to defer to Congress in this matter that so clearly affects interstate commerce. Last month's Supreme Court argument gave me reason to hope the Court will do the right thing. I said at the time, after all, if they could overturn the Affordable Care Act, why couldn't they overturn Social Security or Medicare? There'd be just as much reason to overturn those. The key to the test for constitutionality under the Commerce Clause is whether the law substantially affects interstate commerce. That is a long-established constitutional test set forth time and time again by the Supreme Court. As a law passed by Congress, passed to regulate a market that makes up 1/6 of the U.S. economy, the Affordable Care Act is well within the limits set by the Supreme Court's own precedent on Congress' Commerce Clause power. The personal responsibility requirement that is the focus of the legal challenge It is necessary to ensure that Americans are paid for their health care by buying health insurance and not stuck with paying the $43 billion in health care costs incurred by millions of Americans who do not buy health insurance and they must rely on expensive emergency health care when inevitably faced with medical problems. That is what Congress concluded after extensive study and debate, and what we include in the text of the law itself. There's no question this act by Congress regulates matters undeniably affecting interstate commerce. The outlandish examples of hypothetical laws that Congress has not passed reduce these matters to ridiculous absurdities. They may be popular in Federalist Society circles or on political blogs or those who want to find the Constitution shortened enough to be on a bumper sticker slogan. It has no place in Supreme Court determination. There may come a time when Congress passes a law that is law at the edge of its authority, when the boundary which should be seen as affecting commerce needs to be more closely considered. That time may come. I hope it doesn't. That time may come, but this is not the time, and this is not the case. The Affordable Care Act builds on some of the cornerstones of American economic security built over the last century. I believed when it passed, I still believe today, the Congress acted within its constitutional authority to enact laws to help protect all Americans. Just as some in this country disagreed when the Congress passed Social Security, the court agreed we acted within our authority to do so. You may agree or disagree with parts of the Affordable Care Act, but the fact is Congress acted within its authority. And I hope and have faith that the Supreme Court will not overstep the judiciary's role by substituting policy preferences for the legislative determinations of Congress. Mr. President, I ask my full statement be made part of the record.
Without objection.
And returning to our regular session, Mr. President, I ask that my statements on the nominations of George Levi Russell III and John Thorpe, Jr. Be placed in the record at the appropriate point today.
Without objection.
And Mr. President, I suggest the absence of a quorum, but I ask consent the remaining time between now and 5:30 be equally divided.
Without objection. Clerk will call the roll.
Mr. Akaka?
Two judicial nominations coming up today in the Senate, one for a district court seat in Maryland and another for the Northern District of Illinois, and also a vote on the lending of the Export-Import Bank. An article from CQ says the Senate is expected to overcome the obstacles to move forward on the measure, and that the majority leader appears to have lined up enough votes for a bill that would raise the bank's lending cap from $100 billion to $140 billion. The bank's charter is also set to expire at the end of the month. Senator Reid and Minority Leader Mitch McConnell are continuing to try to reach an agreement on which and how many amendments will be allowed.
Consent quorum call be suspended.
Without objection.
Mr. President, I would like to ask unanimous consent to have entered into the record at this point a statement from my colleague, Senator Mark Kirk.
Without objection.
Thank you very much, Mr. President. Mr. President, pending before the Senate is the nomination of Jay Thorpe to serve on the District Court for the Northern District of Illinois. Senator Kirk and I have agreed on a bipartisan approach to this. We each have appointed committees, bipartisan committees, who review the prospective applicants and then make recommendations. We each have the veto over the other's recommendation, so it is totally bipartisan. But in the case of Jay Thorpe, there was no veto, certainly not by me, and in this case, he was sponsored by Senator Kirk. He's an extraordinarily talented individual. The reason I've entered into the congressional record, the official statement of Senator Kirk, is because obviously he can't be here. He is in rehab at this point from a stroke which he suffered in January, and there was an encouraging video released last week showing the progress that he's making. We're all anxious for him to return, but I promised him in a phone conversation last week I would move this nomination as quickly as possible so that his nominee is approved. His statement in the record speaks to his feelings about Jay Thorpe's nomination, and it speaks for itself. I will add to his comments my own. I'm glad that Mr. Thorpe is finally getting a vote in the Senate. It's taken a long time. In fact, it's taken too long for this day to come. Nominees who are non-controversial, eminently qualified, who go through the committee without even a hint of resistance from Democrats or Republicans shouldn't have to sit on this calendar for week after week and month after month. It's now become standard around here, just like these mind-numbing filibusters, standard around here. And it isn't fair. It isn't fair, first, to the country to leave vacancies on the federal bench, creating hardships in courts around the nation, where people come to the courthouse expecting timely consideration of important matters, from criminal charges to civil litigation. It isn't fair to the nominees. It really takes a pretty stalwart individual to put your name up to be a federal judge, because you're going to go through 3 or 4 different levels of investigation, and some pretty serious investigation. By the Federal Bureau of Investigation, for example, that's part of the process. By the White House, by the Senator's office, by the Senate Judiciary Committee. So it's not an easy undertaking. There might have been a time, I know there was, when these nominations would go through in 48 hours with hardly a question asked. Doesn't happen anymore. Hard questions are asked. And then comes the suspense of starting the process and waiting for it to end. These poor nominees sit there with their professional and personal lives on hold, having said that they are prepared to step forward and serve a lifetime appointment on the federal judiciary, and then they wait day after weary day, week after weary week, month after month, sitting on this executive calendar, so that at some point there will be a bargaining session and some names will go forward, some won't. This is what happened to Jay Thorpe, and it shouldn't have. Nor John Lee, the nominee that was approved last week for Illinois. Both extraordinarily qualified, should have gone through without this resistance, but this reflects what's happened in the Senate. What is interesting about Jay Thorpe is that every aspect of his nomination has been bipartisan. As I said, Senator Kirk put him through a bipartisan process for selection, and Senator Kirk reviewed and approved all of the nominees and then recommended him. It was last November 10th that the White House sent the two nominations that went from Senator Kirk and myself to the White House back to us, to the Senate to fill the vacancies. John Lee, who was approved last Monday, Jay Thorpe, who will be taken up this evening. John Lee was my choice, Jay Thorpe was Senator Kirk's choice. And we agreed, as I said, on both nominees. They were both nominated on the same day. They appeared together at the hearing before the Judiciary Committee in January, almost 6 months ago. Both reported out of the committee in February, about 3 or 4 months ago, in a bipartisan voice vote. It was my hope we could bring them to a quick vote. There was an urgent need to fill the vacancies. We had been contacted by the Chief Judge of the District in Chicago, Jim Holderman, and he'd written to both of us, Senator Kirk and myself, and asked, please move on these judges. And I felt an obligation after Senator Kirk's illness to try to get this job done. I knew Senator Kirk would be here in person if it were humanly possible. I put his statement in the record. I know how strongly he feels about the qualities of Jay Thorpe. Unfortunately, for reasons hard to understand, this has dragged on for almost 6 months. Up until a few years ago, this, as I said, was not the way things were handled. Not when it came to bipartisan nominees that were coming out of the committee with no controversy. And that certainly is the case now. But it's become routine. Routine objections. There's a presumption that something must be wrong with the nominee and we'll just sit on them for weeks and months. That's not good. It's not fair to the nominees. It's not fair to the process. It certainly isn't good for the judiciary. Under the last nominations agreement negotiated in March, for some reason, John Lee made the cut. Jay Thorpe didn't. I appealed to Senator Kyle, to Senator McConnell. I sent a letter in writing, spoke to it on the floor. Now, this is Senator Mark Kirk's first nomination for a federal judgeship, and I know how important it is. I want to thank those who were responsible for bringing it forward today. I'm sure that he'll be relieved. I know Jay Thorpe will be relieved when this is over. I've been very happy to stand up and support Jay Thorpe as well as John Lee. They're both extraordinary individuals. There are other well-qualified nominees sitting on this Senate calendar in a similar circumstance. After today's vote, there'll be 17 nominees pending on the calendar, and nearly all of them, almost all of them, voted out of committee without any dissenting votes, with the exception of Senator Lee of Utah, who votes customarily against all judicial nominees. These nominees, but for a few, haven't had any controversy. 6 of these have been in areas designated as judicial emergencies, including 2 nominees for seats in the Ninth Circuit, Paul Watford and Andrew Hurwitz, who are extraordinarily well qualified. I hope my Republican colleagues will give us a break here. These people deserve to get their moment here on the Senate floor, deserve a vote, and the areas that they're going to serve deserve a full complement of competent jurists. It's time to restore sanity, comity, and good faith to the way we treat judicial nominations on the Senate floor. And it should start today. Let me discuss Jay Thorpe's background for the record. Nominated when the judgeship opened up after Blanche Manning, Judge Blanche Manning took senior status, currently a partner in the Chicago office of Mayor Brown, where he's co-leader of the firm's securities litigation and enforcement practice. He was born into a military family. He's very proud of it, son of a lieutenant colonel in the Marine Corps. Jay Thorpe attended Duke University on an ROTC scholarship, received his undergraduate degree summa cum laude, was commissioned as a second lieutenant in the Marine Corps. He served on active duty with the Marines for 6 years, achieving the rank of captain and earning the Navy Achievement Medal and the Navy Distinguished Midshipman Award. After his military service, he attended Northwestern University Law School, graduated magna cum laude, served on their law review. Upon graduation, he was a clerk for Judge Joel Flom on the 7th Circuit, and then worked as an assistant U.S. attorney in Chicago for 6 years. After his tenure as a federal prosecutor, he joined Mayor Brown, where his practice has been in complex commercial litigation and criminal investigation. He has received numerous recognitions. Serves as an adjunct professor of trial advocacy at Northwestern University Law School and a member of the Law Fund Board of Northwestern, which oversees fundraising efforts. In short, Jay Thorpe is a picture-perfect nominee for the federal bench. He has the qualifications, temperament, and integrity to serve the Northern District as well. I urge my colleagues to support his nomination, and I just say to Jay Thorpe, the day has come, finally. I am sorry that you got caught up in what has become a tiring political exercise here, where people are just stuck on a calendar waiting for something to happen which springs them loose. This evening will be your opportunity. I hope the Senate, and I know Senator Kirk would join me in saying this, will give Jay Thorpe the unanimous vote which he deserves. He's an extraordinarily well-qualified nominee, and I'm happy to support his nomination. Mr. President, I yield the floor.
Mr. President,
The senator from Iowa.
I will be urging the people in my caucus to vote for these nominees, both of them. Today, the Senate is expected to confirm these two nominees, Judge Russell, Maryland, Mr. Tharp, Northern District, Illinois. As I said, I support the nominees, and I do, in fact, expect both of them will be confirmed. We continue to confirm the President's nominees at a brisk pace. In fact, with today's confirmations, we will have confirmed 145 of President Obama's district and circuit court nominees. I'd like to put this in perspective. We confirmed 2 Supreme Court nominees during President Obama's term so far. Everyone knows that it takes a tremendous amount of time and resources to consider Supreme Court nominees. The last time the Senate confirmed 2 Supreme Court nominees was during President Bush's second term, and during President Bush's entire second term, the Senate confirmed only 120 district and circuit court nominees. Compare that, if you will, to the 145 district and circuit nominees that we have confirmed so far since President Obama has become president. Let me say that same thing a different way. We have confirmed 25 more nominees for President Obama than we did for President Bush in a similar time period. And of course, President Obama's term is not over yet. With these facts in mind, I hope my colleagues will understand why I get a little frustrated when I hear all of these complaints about how we're not confirming enough nominees. The fact of the matter is that President Obama is being treated much more fairly than Senate Democrats treated President Bush. It is especially frustrating to hear the other side complain about the vacancy rate. The fact of the matter is that the Senate is doing its job. We're confirming the nominees that are sent to us, and of course we can't confirm nominees that aren't up here from the White House. If there is a problem, then it rests with the President. Right now there are 77 judicial vacancies, but the President has made only 29 nominations. That means 48 vacancies, or nearly 60%, actually 63%, have no nominee. Now, stating it another way, there are currently 44 million Americans living in districts with vacancies where the President has not submitted a nominee to the Senate. I suspect that the President neglected to share that statistic with all the groups that he summoned to the White House 1 week ago today to discuss judicial nominees, probably with the point of getting those organizations to put more pressure on the Congress to approve more nominees and somehow approve nominees that aren't even up here yet for us to approve. Mr. President, I could go on, but I don't intend to. I don't like to get into this back and forth with the other side, but it gets a little tiresome to hear the same misleading statements over and over again, and I want to set the record straight, and I have done that. I congratulate the nominees who will be confirmed tonight. Both the nominees and their families should be proud, and I intend to put the remainder of my statement in the record, and that remaining statement discusses the qualifications of today's nominees and urging my colleagues to support these nominees, and I think that they probably will be supported overwhelmingly. I yield the floor. I yield the floor.
Clerk will call the roll.
Mr. Akaka.
And two judicial nominations being considered today, one for the district court seat in Maryland and another for the Northern District of Illinois, and also a vote on the lending of the Export-Import Bank. An article from CQ says the Senate is expected to move forward on that measure. And next week we could see lawmakers go back to the student loan interest rate legislation. Democrats and Republicans with differing plans on how to pay for preventing federal student loan interest rates from doubling in July. And from President Obama's agenda and his to-do list, we also could see debate in the Senate this week on one of his points, which is a 10% tax cut for businesses that hire new workers.
Mr. President.
The senator from Maryland.
Thank you, Mr. President. I ask that the call of the quorum be vacated.
Without objection.
Mr. President, I am so proud to be here on the floor of the United States Senate